am so happy for your return, my lovely humans. Welcome back to my channel. I'm FCA. We have some Karen Read court catch-up to do. Normally, I can listen to the trials and stuff while I'm at work, but I have been put in different areas of my job where I couldn't listen to anything because I was learning stuff that I have never been trained on. They were like, "You're doing this today," and I was like, so I have not been able, so I've been like trying to catch up in bits and pieces. But I think we're there. I have a couple weeks of court rulings and motions to go through. I'm not going to go through all of the big, or all the little details. I'm going to go through the big stuff that is the most interesting and the most important in my mind. So just for transparency's sake, as in all of my videos, I am not a paralegal or a lawyer or licensed in law in any way, shape, or form. I like to see myself as a person who's viewing the trials that I'm enthusiastic about. And when I say enthusiastic, I don't mean, ooh, I'm happy something bad happened to somebody. It's not like that. It's, oh, these procedures are actually really interesting. Where are we going to go? Oh, that's an interesting defense. That's an interesting counterpoint. That's what interests me, the trial procedures and things, not the bad things that lead to them, just so that we're clear on that too, because I know how the internet be. Anywho, I view myself as someone being the juror. So when jurors are in the courtroom, they're interpreting evidence and what the judge and lawyers are saying, when they're mostly not going to be legal experts of any kind. In fact, it's one of the things that is likely to get you pushed off of a jury is if you are a lawyer. It's not a guarantee, but they tend not to want that, they being other attorneys on a case. So that being said, I am going to link to everything below, as I always do, so you can look up and read and watch things for yourself and make those judgments. I am here to do recaps and catch-ups and summaries, so let's actually get to that part. So one particularly interesting thing is that I just got done saying that lawyers often don't get put on as jurors, but there was a lawyer on Karen Read's first trial named Victoria George. Now, usually their things are protected and sealed, identities and such, and nobody can bother them if they don't want to be bothered. They can come forward if they want to, but they are not required to. Well, Victoria George has come forward because she is now an attorney for Karen Read. And that is a very interesting and unique position to be in. What is fascinating about that is this is a very unusual opportunity for the defense team, because since she's on their team, they can all talk and discuss things. She's allowed to say whatever she wants to them, and now that there's attorney-client privilege, she can say what she wants to her client. Okay, well, what were some stronger points? What were things that were annoying, because they made deliberations, so she knows all that stuff. So even though they're not allowed to ask her exactly what happened in deliberations, they're allowed to ask her, like, what was the vibe? Where could we make stronger arguments? Where do we need more assistance? Where do we need to, like, pull back? My fan, for no reason on my computer, just decided to go. Like, I don't even have any programs or anything up right now, and it just went to level 10. I'm so sorry if you can hear that. My microphone's kind of close to my laptop. Anywho, this is their opportunity to get to go, make those arguments and points. It was an interesting, very, very early, that happened a couple weeks ago. I'm so sorry for the cold tea, but that is where we are. Then the second thing, I have my notes in case you're wondering what I'm reading over here. Now, court popped off again with Judge Cannone making a second ruling from the bench. This is the second time in 2 years that she has made a ruling from the bench, at least in this trial that we've been able to watch and see. She takes almost everything. She's like, I'm going to take this under submission. I'm going to take this under submission. We're like, please make a ruling now. It's a very simple thing. Just yes or no this. But she did make an immediate ruling from the bench. And let me tell you, so the prosecution, Special Prosecutor Brennan, has been one of his overarching themes, one of his new things that he's bringing to the second trial is he wants to use Karen Read's words against her. He wants to bring the outside of court into court, because during the first trial, there wasn't a lot of, or any media for him to pull from, or from the prosecution to pull from, and they didn't go down that way at all. Where if you watched the Hannah Gutierrez Reed case from the Rust trials, she was the armorer who was convicted of being a part of the unaliving of Helena Hutchins. And in that trial, the defense or the prosecution just played her talking to law enforcement. They let her words speak for her, and for some reason her lawyer didn't shut her up. Don't understand that. That's what your lawyer's supposed to be for. But he didn't do none of that. And in this trial with Karen Read, she has made, in the second trial specifically, there's been a docu-series where she's been making statements. There have been magazines. There was the Gretchen Voss interview. And so there's more statements from the defendant coming forward, and Brennan's going to use that to incriminate her, going, this is why she's guilty. She said these things, and she said them like this, and her lawyer told her these things because she's guilty. This is showing that she was guilty at the time, and that's part of the reason why you should convict her, is because she said these things, and she's only saying these things in this way because she was showing guilt for her actions. That's the direction that he was going. And bro wanted everything. Okay, he wanted every uncut interview. He wanted every written note. He wanted every piece of raw footage off of the editing room floor. And he wanted every text message between Karen Read and literally everybody, including her attorneys. He made a specific motion to get some things that he suspected may have been with Turtle Boy, which I will link to a video explaining that specific whole craziness. But he wanted that, and there were also messages between Karen Read and her attorney, David Yannetti, that he wanted. And so he makes his arguments. Then it's Alessi is up there, another one of Karen Read's attorneys. He's getting into it. He's making his argument. He's on the ball. And the judge full on interrupts him mid-sentence and goes, Mr. Alessi, I'm going to cut you off. And the look on his face, oh my gosh, I'm going to try to get the screenshot of his face. And there's a journalist or reporter in the background who's like, wants that tea so bad. And it worked out in their favor because Judge Canone ultimately ruled. She just said, Mr. Brennan, I'm not giving you any of this. This is clearly attorney-client privilege. And she expressed that it made her uncomfortable to have to read it to make a ruling on it. And even had specifically said, I don't feel like it's appropriate for me to see, much less for your eyes to be seeing. Like, this is attorney-client privilege. You're not getting any of this. This whole list of things that you asked for doesn't apply here. You're not touching it. So that was her ruling from the bench. And then that was the only real win in the last week or so for the defense, though. Their expert that they wanted brought in was denied, and the expert that they wanted brought in this time was a procedural expert. So this would be an expert who would be able to explain to the jury, like, okay, what are proper police procedures and investigation procedures? Is this appropriate? Is this the way that this should be done? If this is an incident that happens in this way, what are the steps that need to be done? That is the expert that they were going to call in, because since law enforcement is excluded from being on a jury panel, regular day-to-day people, you, me, he, she, them, pretty much don't know exactly what should be police procedure, proper police procedure, because, like, is the collecting blood evidence in red Solo cups sus to me? Yes, but that might be a thing where it's like, listen, if you're in a pinch or in a last resort, you gotta get it up somehow. These are appropriate vessels, and you know what? It's a plastic container. They were cleaned, they were unused, they were freshly opened. And for that situation, for collecting, yeah, that's perfectly fine. Maybe that's true. I don't know. I don't think so, but maybe it is. And so if you have an expert who goes, well, yeah, and when you're in a desperate clutch situation, you have to have some sort of a clean vessel that is unlikely to produce its own cultures, and a plastic Solo cup, while unusual, is good in this situation. But the judge just full on said, I've never even heard of that. And that blew my mind. Does that blow your mind that a judge said, I've never heard of an expert or bringing in an expert on police procedures? We have the police. You ask them about police procedures. You want investigation procedures? Ask the investigator. That's who you ask those questions to. We don't need a separate expert to go, yes, 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 no, 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 no. And I'm like, apparently that's just how they do it in Massachusetts, though, because Judge Canone listed a bunch of law, and she's like, this is just not done here. And I'm not surprised by that, because what I have learned is Massachusetts, they just do it different. In a lot of other states and a lot of other trials, the Massachusetts people just do it different. Is this police procedure? Have you ever done that before? Is this what is recommended? Is that what you were taught at the academy? You can hone in on that. And I think that that's a very good thing for the defense, based on the way they've been arguing their other things, showing how just shoddy this investigation was from the get-go. If you start asking the police there, like, is that what you've done before? Is that standard? Well, no, it's not standard. Then why did you do it? If you know that's not how it's done, you know that's not right, why did you do it that way? Why in this specific case did you do it that way when you know it's wrong? Or vice versa, whatever might happen. The next big thing that popped off was that the third party culprit defense that the defense put forward, they were specifically making a motion to include Colin Albert. This is Colin Albert. He is one of the people who was maybe possibly at the Albert's house the night of the incident, but then he left before John O'Keefe got there, etc. It's very confusing. But anyway, the third party culprit, I did not cover this in my in my explanation of words, of court words, because those were the ones that are more common. Third party culprit, this is the first trial I've watched in the last 6 years that has brought up third party culprit. Third party culprit is exactly what it titularly sounds like. It is the defendant didn't do it, but we have a person who did it. That person did it. So, not her, them. And the defense in the Karen Read trial was pointing those particular fingers at Colin Alberts, Brian Alberts, Colin Alberts, Brian Albert, and Brian Higgins. I am very conflicted, by the way. I do not know if it is Albert, if their last name is Albert, singular, or Alberts, and it just refers to the Alberts as a group, or if their last name is plural. So apologies for me going back and forth. They go back and forth with it in the actual court trials and things. As on the stand, and one of the things that the defense was really trying to go for was showing that John O'Keefe got into a fight at the Albert's residence, and the dog Chloe attacked him trying to defend her people, and hence the marks on his arm. And that he did have things, there were multiple medical experts who had said this was a person who was hit or possibly beaten. His injuries are not consistent with being hit by a car. And they were trying to show that Colin Alberts was one of the perpetrators in John O'Keefe's passing that he instigated, got into a fight with O'Keefe, and it went too far. And then all of the family helped cover up for Colin Albert. There were text message exchanges between him and Allison, aka Allie McCabe, and their text messages suddenly cut off, and they were like, oh no, we just always switch between different things. Like, we were texting, and then we were kind of using Snapchat and DMing on other things. And when he was asked by Alan Jackson, of course, if like, oh, did you use Snapchat because those automatically delete? And you just like, we're just people who use Snapchat sometimes. Brian Higgins, as we had mentioned before, that he was Karen Read's alleged on again, off again, other possible lover, with some of the cringiest flirting on the planet taking place in their text messages. And then Brian Albert, of course, standing up for his friend and fellow cop Brian Higgins, and or for his son Colin Alberts. Colin has been known to get into multiple fights. There were videos that were brought in. I will show some snippets here of just because I'm not sure where I fall in copyright, so that's why I'm just showing screenshots instead of playing video of him getting into fights, threatening people, threatening to beat them up. And he had, shortly after the incident had happened, there was a picture of Colin Alberts, and his right hand had bloody knuckles. Like, his knuckles here were looked like they were healing from being scraped and cut open, like he had punched something. His reason for that was that when he was holding something in his hand, he fell on an icy driveway, and to stop himself, he caught himself with the front part of his knuckles, hence why he had injured knuckles and hands. Okay. He said he was holding something, a drink or something, and he didn't let go of that before he fell and hit the ground to stop himself like this, that he just kept holding the thing and stopped himself, caught himself. You can make of that decision up for what you did. Listen, sometimes weird things happen to people, but basically in terms of what that meant for the third party culprit was, though, that was really it that the defense brought in the first trial, and Judge Cannone ruled that that wasn't enough evidence. It wasn't really evidence, just kind of theoretical speculation at best of Brian Albert or Colin Albert being a third party culprit that also got into a fight or may have gotten into a fight with John O'Keefe. The evidence is also not sufficient, according to Judge Cannone's ruling, that that isn't enough to prove that he was even near the residence when John O'Keefe allegedly was there. The timelines just don't add up for when he was texting Allie to come pick him up, and when he actually left. He also claims that he never saw John O'Keefe, but that he left relatively early compared to everybody else, and that he never even crossed paths with or seen Karen Read's car or anything. And Allie also backs that up. And Alan Jackson pushed really hard to get the video in because he wanted to show the jury as a party. He was trying to do an underlying thing for third party culprit that, you know, this is who he really is. He looks all dressed up and nice and just kind of forgetful, since every other answer that Colin Albert gave was, I don't remember, in the first trial. And Alan Jackson claimed he was trying to Eddie Haskell it. Eddie Haskell being a scheming person in a really old 1950s, late 1950s, early 1960s sitcom called Leave It to Beaver. He was the older brother's best friend, and Eddie Haskell was known to be like kiss up to parents and overly polite and well-mannered to parents and grown-ups, but then be a scheming little jerk to everyone around him and to do pranks and schemes that he would set his friends up to take the fall for. So kind of that two-faced thing. Like, oh sure, in court he's like, no, I don't fight. I've never gotten into a fight. I don't remember anything about a fight. And then you show him saying stuff like this in video form. Stuff is like, okay, bro just said that he's never gone into a fight. Here are some things of him fighting. Okay. And Judge Cannone, not happy. Okay, not happy with the third party culprit motion against Colin Albert. So she denied that one, but she allowed for Brian Albert and Brian Higgins to still use the third party culprit defense against them. She said that otherwise you're going to have to rely on a Bowden defense. Bowden defense is where you show another poopy part of the investigation, where it's like, listen, there was all this evidence, all these people were here, and they were other possible suspects or had plausible involvement in this, and the investigators didn't look into them. They just targeted Karen Read and left all of these other more viable culprits off their list. And so the Bowden defense is to show where investigation went wrong, and that if other people, other theories and leads had been followed and better investigated or investigated more thoroughly, then you would be closer to the truth and accurately what happened, and instead they just pin-blamed Karen Read. The last big thing that has happened is there has been the hearings over jurors. They already have 8 seated jurors. I think that they want 16. I'm not 100% sure on that number. I've heard it said several different ways, but in the case itself, there have been 8 seated jurors, which is amazing that they're already just a few days in to this trial, and they already were able to seat that many jurors. That's very impressive, very good for them. Probably not great for the defense wanting that extra timeline, but we'll see where we go to with that. And just to be clear, it's not that nobody has to have ever heard or caught wind of it. They just can't have any details or predetermined opinions made about it. We're like, yeah, I heard about it, but I didn't look into it. I don't think one way or the other about it right now. It's just, oh, that's happening in my area. So that is that thing. I'm going to make another separate video about Judge Cannone getting sued, because that's not connected. I mean, it has to do with the Karen Read trial, but it's not in the trial itself. So I'm going to make those 2 separate videos. So if you want to hear about Judge Cannone getting sued, you should see the next video, where I'm going to look exactly like this because I'm recording it immediately after.